cut y'all off. You just asked me what my defense was. And
all right, I'm done.
wow. You're asking me what my defense is. I can't.
Take her out. I've asked her 3 times to stop this. All right, I'm going to grant your judgment in this particular case.
I object. The court cannot declare its own jurisdiction to respond to it.
If you keep interrupting me, ma'am, you're going to get held in contempt of court, and the court does have contempt powers, so you're in jail. Ask multiple questions, then I'm just going to silence you. So you get the opportunity to ask your questions, or you can just be silent.
I don't have a real opportunity to ask the questions. So at this point, like I said, I'm just going to have to get the federal court involved and get the marshals, because I don't know what you all are going to do. You all have not been acting in honor and with good faith. So I don't know. I'm stuck on
contract on their own.
What are you talking about? I have the right to rescind a contract by right of common law.
Ms. Battle,
that doesn't involve court.
Ma'am, you need to stop talking, or you're going to get held in contempt of court. The court will call the case of the Ranches of Rosebrook versus A Nice Battle, case number 25C-1245.
Good afternoon, Your Honor. David Fanter on behalf of the plaintiff.
Ms. Battle, please hit *6. Unmute your device.
Hello? Hello?
Please state.
It's a niece battle on a special appearance for the record to contest the jurisdiction and the facts before this court.
Yep. All right. Well, Ms. Battle, I'll tell you that this matter is appropriately in the correct court. The court does have jurisdiction.
And that's based on what? What is on the record that is based on that the court has jurisdiction?
The fact that this is a case that is within the jurisdiction of the Township of Ypsilanti, and if you have issues related to any contracts, that would be within this jurisdiction as well. So all of that is within the jurisdiction of this court.
So you're saying that the contract is in jurisdiction of the court?
That is what I just said, ma'am.
All right, and the contract has been rescinded. So how is the contract in the jurisdiction of the court if it's invalid?
Well, gets to rescind a contract on their own. That's
what are you talking about? I have the right to rescind a contract by right of common law.
Ms. Battle,
that doesn't involve court.
Ma'am, you need to stop talking, or you're going to get held in contempt of court. Mr. Fantier, have you had a chance to talk to Ms. Battle? Talk to Ms.
You're breaking up. I can't hear you.
Mr. Fantera, do you need to speak with her, or are we ready to...
If you want me to speak to her, I'll speak to her. You know, I mean, she talks about rescinding the contract. Does that mean she's moving out?
I'm sorry, you're breaking up.
Are you moving out?
Are you moving out?
No. Why would I have to move out?
Because if you rescind a contract, okay, fine. Your Honor, I think let's set this for trial.
Okay. One moment.
This case has also been in the it's in the circuit court. A petition filed for an injunction. I did serve you all. It is set on the 30th.
Yes, ma'am. I heard.
We're aware.
Okay. And once again, I do not submit to the jurisdiction of the court. The contract is rescinded.
So how can the contract...
And I am not a legal person.
You're not a legal person?
How can a contract... No, I'm not a legal person. I'm not a legal entity. No, I am not. And you have to prove that on the record.
Actually, I don't.
I'm sorry?
Can I ask Ms. Battle a question, Your Honor, real quick?
Sure.
So, Ms. Battle, so you can live there forever without paying rent because you're not a legal person?
That's not what I'm saying, but the contract itself is invalid. I'm saying that you don't have any personal or subject matter jurisdiction over me. Over an invalid contract, no. And over me not having a legal capacity to be sued, yes. So if that's how you want to take it, then that's how you have to take it. But that's what's lawful, and that's what's written in the law.
Let me just tell you, I think you're wrong on both counts. I would expect that we would...
It's okay for you to think that I'm wrong, but the facts still align with what I'm saying.
Okay, Your Honor, I think we should have a trial.
You have to prove without the reasonable doubt. So let the record show that the judge has not required the plaintiff to prove without a reasonable doubt that I am a legal person, and it's on the record, not assumed, not presumed, on the record. There's nothing that's on the record that states.
Ms. Battle, first of all, reasonable doubt is a standard in a criminal case, not a civil case. So I do not have to prove anything beyond a reasonable doubt.
Sarah, I need both of you to stop talking, please. Both of you, I'm sorry. I cannot figure out the date because I can't hear over the two of you.
I apologize. I didn't know that's what you were doing, Your Honor.
Yeah.
All right, Mr. Fantera, are you available on May 6th at 3, you said? At 3 p.m. for trial?
What's that, a Tuesday?
Correct.
Yes.
All right. This matter will be scheduled for May 6th at 3 p.m. for a trial on any and all issues that may be before the court. Ms. Battle, if you have anything else that you need to say, you can unmute yourself by hitting *6 to do that.
Okay, I just find it ironic that I got muted when I was speaking on jurisdiction and how there was a lack thereof on the record. So I want that to be on the record. But I also wanted to, okay, that's fine. And I also wanted to be on the record that I am not going to be able to show up on May the 6th. So it's also ironic that you are able to verify with him that he's able to show up and not with myself.
I just asked you that, and you are now talking about something else. Why can't you do this?
That's because you cut me off and put me inside of a break room and muted my mic instead of allowing me to speak on what needs to be spoken on.
All right, this is set for May 6th at 3.
Your Honor, by Zoom? By Zoom?
Correct.
All right. Thank you, Your Honor.
It's ridiculous. This is a fraud upon the court. Goodbye. Ms. Denise Battle.
Thank you so much, Ms. Battle. All right, today's the time scheduled for a hearing in this matter. This is an action to terminate the tenancy based on non-payment of rent.
Yes, Your Honor. I object to these proceedings moving forward because, like I said, I do have a verified petition in emergency motion for injunction in the U.S. District Court, which is the case number 25-CV-11233.
Thank you, Ms. Battle.
And like I said, this court has not put on the record of their jurisdiction. There's nothing on the record, and it stands. Every notice that I've sent is unrebutted, which stands at law. And jurisdiction is a threshold issue that we shouldn't even made it this far without discussing proper jurisdiction.
All right. Anything else, Ms. Battle?
As of right now, no.
Okay,
That's
thank you.
but I object to these proceedings in jurisdiction, subject matter, and personal.
All right, your objection is noted for the record. Ms. Battle, I've already ruled on jurisdiction when we were here last time. We will be proceeding today. The court does have jurisdiction. Mr. Fantera, and Ms. Battle, do either of
The
you
court
have?
cannot, I object. The court
Ma'am?
cannot declare its own jurisdiction
If
to
you
respond to
keep interrupting me, ma'am, you're
This is the turning point. Once a judge rules on jurisdiction, continuing to argue it stops being strategy and starts becoming risk. From a sovereign citizen mindset, repeating no jurisdiction can feel powerful, like standing on principle. But in actual legal practice, once the ruling is made, persistence doesn't strengthen the position. It weakens it. It erodes credibility. And in court, credibility is currency.
of court, and the court does have contempt powers, so while you're in jail.
I interrupted you. Okay, that's all.
Your Honor, I want to point out also that Judge Vandenberg actually addressed this issue last Wednesday and said that the 14B District Court and Your Honor does have jurisdiction over this matter. So not that it needed to
May
do
I
that.
add, Your Honor? Yeah. She also said that she was not aware of the things going on, so she just went on for anything based on what he just said. She said any law nor facts, just as you don't, of why you have jurisdiction. And it's no order that has it back yet, to be clear.
All right, thank you. Again, Ms. Battle, this court has jurisdiction and we will be proceeding today. Mr. Fantera, if you, well, actually, the both of you have an opportunity at this time to do any opening argument that you want to make. So, Mr. Fantera, I will start with you. Do you have an opening statement?
I'll waive my opening statement, Your Honor, and just get right to the evidence.
All right. With respect to service, can you please put on the proofs regarding the service in case there is an appeal?
Say that again, Your Honor.
Can you please put on proofs regarding service in the event that there is an appeal?
Service of this lawsuit?
Yes, on Ms. Battle.
I believe that she was served by a court officer with Jimmy Moore's office, Your Honor. I think there's a proof of service in the file. I don't know whether it was attached or whether it was personally served. But the court has that proof of service.
With respect to proof of service, the file indicates that Ms. Battle was served with two different ways pursuant to MCR 4.201D, which is she was served, actually three different ways. She was served with an original mailing from the court, and then a second mailing went out from the court. Second mailing was requested by the plaintiff and was sent by this court. On March 28th, there was a mailing. And then there was service by Edward Cope, who was the court officer. That service was effectuated through securing an attachment to the main entrance of the tenant's dwelling unit. And that was done on April 4th, 2025. And after attempts had been made on April 2nd at 12:40, and then April 3rd at 9:53, they finally did an attachment on April 4th at 4:30 p.m. In addition to that, Ms. Battle showed up to the court on April 9th, 2025 before the magistrate, therefore acknowledging that she had received service in this matter and that service had been perfected. Right. With respect to jurisdiction, we addressed that at the last court hearing. This is on Russell Court, which is within the jurisdiction of Ypsilanti Township. I think you hung up.
Your Honor, when she comes back, can we require her to, she appeared the last two times with a video. Can we require her to have video today?
Ms. Battle, are you back?
Yeah, we were disconnected.
Yes, Ms. Battle, you're back. All right.
Yeah.
What request were you making, Mr. Fantera?
I know the last two times that Ms. Battle has appeared, she appeared with a video, and this time she's just on her phone. Can we require her to be here by video today also?
I would have had to give
Well,
her.
the thing is like I tried to tell you all last time that the time was bad. This is when I pick up my kids.
Right.
All
So
right,
if we
then
can
we
do
can
it
just,
like earlier or something of that nature, yeah, that's fine.
then I'm okay just proceeding as long as the court is comfortable that we can swear her in when she goes to testify.
Thank you. I am comfortable. I can tell you that if I was going to require that she be here via video, I would need to give her notice of that prior to today's date. So I'm comfortable proceeding as we are.
Okay.
All right. And Ms. Battle, other than jurisdiction which has been noted and reserved, do you have any other argument you want to make today with respect to this matter in terms of an opening argument?
Of course. So, like I said, the contract has been rescinded on April 1st, and it was due to unconscionable pieces in the contract, including pieces that's wrong with the formation, as well as material breaches that's inside the contract. That
Material,
contract has not been
you said
material
material.
breaches.
Oh, okay, go ahead.
Breaches, yes, within the contract as well. That was sent out and received. Well, it actually wasn't received on April 1st because at the end of the day, the unconscionable pieces, their addresses are wrong and the owners are wrong on the contract, so it got sent back. But once I realized it was sent and received on April 8th, 2015, and still remains unrebutted. They have yet to unrebut it in any case that we came and talked about the contract. And by law, according to Wall versus Zendaya, the Michigan law recognizes rescissions at common law for breach, fraud, and unconscionability. Meaning, if I give notice and it's unrebutted, that stands at law. Also, I've talked on personal matter jurisdiction, in which why I came in under special appearance the first two hearings, because at the end of the day, I'm not a legal person. I'm not in a legal capacity under Michigan law. I do not qualify as that person, which that person is a corporation, a trust, individual, in some type of legal entity of that nature, an association. I do not qualify as one of those people to be here and subjected to this without consent. Hence why, things were sent administratively and defaults were given administratively, because things are happening right here where I'm being deprived of due process, and I should be awarded due process by law. As the attorney stated last time we were here, he was saying that basically the burden of proof only applies in criminal cases, which is false, because the burden of proof applies in all civil cases where jurisdiction or contract validity challenged, and that's Taylor versus Bullock in 1992 in Michigan. You still have the burden of proof. The court cannot establish their own jurisdiction being based on a contract is rescinded. You have to have a valid contract to come into court about. So that's where your jurisdiction of the subject matter is at hand, because the contract is rescinded, not unilaterally, like he's tried to claim before. It is rescinded, meaning I gave you notice and it's unrebutted, just as if somebody came into the courtroom for an eviction, or if they did not come for the eviction, you'll give them a default, because what happens at law, your silence stands.
All right, thank you, Ms. Battle. Mr. Fantera, you may proceed with your case.
Plaintiff would like to call Dawn Charles as a witness.
All right, Ms. Charles, please raise your right hand to be sworn. You swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing.
I do.
Thank you. You may lower your hand. You may proceed.
Ms. Charles, please state your name for the record.
Dawn Charles.
And what is your position with the Ranches of Rosebrook?
I'm the property manager.
Are you familiar with the tenancy of Anise Battle?
I am.
Are you familiar with the lease agreement that she signed?
I am.
Your Honor, I submitted to the court a lease agreement dated November 12, 2024, I'd be moving for that to be admitted as plaintiff's exhibit.
A needs battle appearance, especially not generally.
Thank you. All right, we're here for the continuation of the hearing today. Battle, when you're not speaking, please.
You said, can I mute my mic when I'm not speaking?
Correct. Thank you. All right, Mr. Fantera, I believe that we are in the middle of your, well, actually it was Ms. Battles. Direct,
Yeah, I think Ms. Battle was cross-examining Ms. Charles.
that's correct. Ms. Battle, are you ready to proceed?
Yes. So Don, do you have a signed lease between me and you in this case?
Yes.
Did I ever waive my rights or agree to terms in writing?
What's the question?
Did I ever waive any of my rights or agree to your terms in writing?
Your Honor, I object. I have no idea what that means.
Meaning that there are waivers inside of the lease.
Your Honor, she's got a signed lease. That lease was, we moved to have that admitted last time, and it was admitted. Ms. Battle did not object. So I don't know what she's asking right now when she talks about a waiver. She signed the lease.
Okay, that's fine. Are you aware of the notice of rescission that was sent?
Yes.
Your Honor, I object. Rescission, we can't go down this road again.
Why are we not going down the road?
Let him finish his objection, please.
Okay.
Your Honor, this case is not about rescission. It's about, this is a non-payment of rent, pay and stay case. The question is, how much money does she owe in order to stay in her lease? She believes, and she stated, and she was overruled by Judge Vandenberg, and I believe by you, that her belief that she rescinded her lease and therefore she gets to stay until she finds a new place is not the law, and she should not be allowed to pursue that line of questioning. This is not about rescission, which, by the way, she hasn't done anyway.
All right. So your argument is that her question is not a legal question and therefore you object.
It's not based upon law.
It is based upon, what law is it not based upon? It's based upon common law. You have not proven or stated any laws or facts that back what you're saying. Unlike me, I have.
Yeah, but you stated them all wrong. And one of the things you stated was the Magna Carta, which was from the 12th century in England.
No, I stated it under common law
Please
and
stop.
landlord-tenant acts.
That's not, we're not under common law anymore, ma'am. And that's a part of the problem with sovereign citizens. They think they know the law when they don't. That is
Well,
not.
that sounds prejudiced and biased because I'm not a sovereign citizen. So it seems like you're trying to group me in with them, and that I am not.
Well, whatever you're using as your basis is still not correct. It is not the
It
law.
is. It's still under
We're
MCL
not
and it's under the landlord-tenant act.
overruled.
My objection is overruled, Your Honor.
No, the objection is sustained. Her question, it cannot be asked.
So you're saying I can't ask about the contract that's in question?
No, I'm saying that you have no basis for asking whether the contract was rescinded or not.
Why would I not have basis for asking if the contract was rescinded?
That's not the law. You don't get to unilaterally rescind anything, ma'am.
Well, again, as I stated,
My ruling, I'm not arguing with you anymore about it.
right, it's not an argument. So just let the record show that there is no law or basis to what she's saying. And she has not yet stated any law or fact behind this objection to asking these questions. I will continue. I will continue. Okay. Did you write me a notice to quit filing this action?
A notice to quit?
Yes.
No.
I think she's referring to a demand for possession,
A
Dawn.
demand for possession, yes.
No, a notice to quit.
No.
Right. Do you have proof of delivery or service of any notice to quit?
No, I didn't send one.
Right. Are you aware that MCL 657-16 requires a notice to quit before initiating an eviction?
Your Honor, I object. Miss Battle is confusing the term notice to quit with demand for possession. A notice to quit is how you start a termination of tenancy case. This case was started with a demand for possession. If Miss Battle wants to use the wrong term, she's going to get the wrong answer. The statute says that we can start a non-payment of rent case with a demand for possession, and that was issued. And if she asked that question, Ms. Charles can answer that question.
Is there proof of service? Is there a proof of delivery on
Battle.
that demand for possession?
Miss Battle, can you do me a favor, please, ma'am?
Yeah.
Give me one moment. You studied a statute that I actually need to look up. MCL what?
I'm sorry.
What was the statute that you cited?
MCL 657.6. I mean, not 57.6, 600.5716.
Yeah, have you read that statute?
Yes, I had read it when I first did this.
It uses the term demand for possession.
Okay, everybody please stop talking. It says a demand for possession or payment shall be in writing addressed to the person in possession and shall give the address or other brief description of the premises. It's a demand for possession, not a notice to quit.
Okay, so is there a proof of service of it on the record?
That's a different question though. So, okay, go ahead.
But that's the question I asked next. Once he said that the
But I
demand for
wanted to
possession.
clarify your question before.
I appreciate it.
All right, Ms. Charles, please add her question next is there proof?
Do you have a proof of delivery or service for that demand for possession?
Nope.
Nope. Did you know that under MCL that you're required to have a certificate of service or proof of service on the record?
Your Honor, I object. She's not using the statute changed 10 years ago so that you now need on a demand for possession a certificate of service. And that's what's at the bottom of the page. If she's looking for a proof of service, meaning somebody going to the door, she's going to get the wrong answer again. The term is certificate of service, and I believe Ms. Charles will answer that question differently because there is a certificate of service at the bottom of the demand. So I would appreciate if she's going to cite statutes, she cites them correctly.
Okay. That's fine. I didn't cite an exact statute, but I appreciate your objection. I just said MCL because they're both under MCLs. Both proof of service and certificate of service are both under MCL.
No.
All right, everybody. So let's not make my ruling.
Let's just okay. All I'm trying to do is ask questions to make sure certain things are on the record. A certificate of service.
Okay.
It's not on the disposition, and just like she read on 657.16, was the property described on that disposition?
Yeah.
Was there a description of the property?
Yes.
If there was a description of the property?
Correct.
On my copy, there is no description of the property. But let's continue. Does your company participate in HUD programs or accept federal HUD assistance?
Yes.
Okay. Did you provide me with grievance procedures required by HUD?
Did I provide you with what?
Grievance procedures required by HUD.
Your Honor, I object. That's irrelevant. There are no such grievance procedures under this anything that I'm aware of. I mean, I don't even know what she has a grievance about.
Right. The grievance would be with the breach, and you all have a grievance, and hence on why you initiated a hearing for the breach of the contract. So it goes back to HUD because you're publicly funded, right?
No, we're not
And-
No,
public.
we're not public.
Well,
Now,
you
what-
accept HUD housing. You accept HUD housing and you apply and you are in compliance with HUD laws and policies, correct?
Yes.
Right. Okay. So if you have HUD terms and you're
Your Honor, I object. Miss Battle is taking.
object to it, I didn't say anything yet.
Well, I'm objecting because she asked Miss Charles a question, which was, do you get any funding from HUD? Yeah, most companies do. We do. And then she takes that and starts taking that to a next question where it says, well, when you get funding from HUD, and then she's assuming.
I didn't assume anything. I asked the question.
Okay, what was the question you were going to ask?
I said, do you have to follow HUD's policies? That was my next
And
question.
she said yes.
Right. And then you objected after that.
No, and then you started the next question.
No, I started the question, but I didn't get it out my mouth
Everybody,
before you
please
objected
just
me.
Let her ask the next question, and if you have an objection, I can hear it after she finishes her question.
Okay.
Okay. Are you aware that before you initiate a hearing in court or the administrative process before court, you have to have an administrative hearing by a HUD administrative judge?
Your Honor, I object. I'm not aware of any.
Say no. I mean, that's
Just
not.
say no because you're not aware, and that's okay to not be aware. That just means that you are not aware of the laws that govern.
No,
No,
it doesn't,
it-
because
it-
that is not the law, ma'am.
How is it? Okay.
You're making.
Are you aware of the requirement under 42 USC 1437 DK for federally funding or accepted landlords to resolve disputes through HUD before an eviction proceeding?
Your Honor, again, I'm going to object. The fact that Ms. Charles answered the question about having a relationship with HUD doesn't mean we are a federally funded property.
I didn't say that you were federally funded. So let's be clear.
Just read-
I said either federally funded or get federal funds, which you do if you accept Section 8 and vouchers.
No, that's not true.
Why is it not correct? You had to think about it. Yes, it is correct. Because if you receive any type of funds from HUD, which is through Section 8 vouchers or regular vouchers, you get what I'm saying? You receive funding from HUD.
We are. Do you?
I'm not
receive
saying
vouchers?
that I'm not saying that you're funded and that they give you loans of that nature. I am saying that you are within their practice and policies of HUD guidelines because you accept HUD in Section 8.
Your Honor, I object to this whole line of questioning. Ms. Battle does not receive a voucher, and so all of this questioning.
Well, it doesn't matter if I receive a voucher. It matters that you are of that type of entity that needs to go through HUD because you accept those things. So
Your
you
Honor,
agree with those terms and policies of HUD.
Your Honor, she's making that up again.
I'm not making that up. If you're saying that, how am I making it up? It's under 42 USC 1437 DK.
Battle,
It's a
Ms.
federal
Battle.
registrar on it.
Ms. Battle, you've made your record. My ruling is still that every entity that has to file a landlord-tenant action does not have to go through that process to collect rent, ma'am. That is not how it works.
Okay. Okay. You're saying that it doesn't have to, but HUD says that
not a
these are
debate.
the
None.
requirements. Hence why MCL at the bottom is trying to align with HUD guidelines on the same registrar that I'm talking about. You have those codes at the bottom that match up with HUD.
Move on.
Okay. So, well, obviously, if I can't really get a line of questioning, I'm being objected because he feels it's not right. He is objecting with no laws or facts behind anything he's saying. He's just thinking it off the top of his head. I'm not getting a fair hearing here.
Ms. Battle, move on.
Move on to, okay. Do you have a copy of the court establishing jurisdiction?
Who's that a question for?
Dawn, my plaintiff.
Your Honor, I object. The court's already said they have jurisdiction over the
The
property.
court said that she had jurisdiction because she said so, and that's non-judicial.
Okay. Ms. Battle, move on.
Move on to what? If
not
I
asking for
cannot
questions.
have, this is not a fair hearing. And
No,
again,
this
this is
is not,
why
you're trying to turn this into a
I'm not
conversation.
trying to turn it into anything. I'm just
I'm
trying to
so done.
state the
Please.
laws, and I'm not trying to argue with y'all
Please.
about anything. You get what I'm saying? I'm not trying to argue with y'all. I'm just trying to get y'all to state and prove y'all facts, and y'all have not proven any facts. But for some reason are hindering me in this proceeding. And that's why I took this case to the U.S. District Court in Eastern. That's why there's an open case right now with
Okay.
all of you all, because this is just not. And I told the Attorney General, and I told the IRS, and I did everything else, because at the end of the day,
Now, please
all
move
of
on.
this is not
I'm
right.
telling you
And
now
attorney
that I'm going to
grievances.
be filing criminal proceedings against you for all these frivolous things that you're filing against me. So
If you
please
feel that
move
it's
on.
frivolous, that's fine. But it's not. My
Well,
rights
this is
and
what the
my
Attorney
rights are
General
not
said.
frivolous.
Please move on.
It's honestly, if I can't have a fair hearing, nobody has any facts. Y'all talked about constructive possession. Nobody wants to talk about that. Y'all keep saying that I rescinded a contract unilaterally. That's not the case. It's called notice. And when a notice goes unrebutted, just like if I was to come here, if I was to get that notice of dispossession and get a notice of a hearing, and I missed that hearing because I
Ma'am,
did not rebut,
Yeah,
that would constitute
Your
no,
Honor,
as
Mr.
cross-examination.
Battle, if
that
you're
would
not going
constitute
to
as the
ask
same
appropriate
type of
questions, then I'm just going to silence you. So you get the opportunity to ask your questions, or you can just be silenced.
I don't
Well,
have a real opportunity to ask the questions. So at this point, like I said, I'm just gonna have to get the federal court involved and get the marshals, because I don't know what you all are gonna do. You all have not been acting in honor and with good faith. So I don't
ma'am,
know.
I don't know
I'm
what's wrong
stuck
with
on what to
you.
do.
There's
The integrity of the
clearly
court is
something wrong
questioned.
with you. I don't know what that is, but you should seek some mental help because
I'm
something's
sorry.
wrong with you. You have
You
a
said
mental
what?
problem. You have a mental problem.
I
If
have a
you think
mental
the
problem.
laws in the
How?
United States don't apply to you and you get to make them up as you go along, like you know more than everybody else in the world, there's clearly something wrong with you.
No, what did I make up?
All of it.
What? Be
Anyway,
specific. No, be specific, because
no,
now you're lying on the record. This is perjury. I
no,
didn't make nothing up.
okay.
42 USC definitely applies to this case.
All right. I have muted.
Jurisdiction is a threshold.
Ma'am, if you don't stop, I'm going to remove you from the court proceeding. So, Mr. Fantera, apparently we're not going to have a reasonable hearing here today because Ms. Battle feels as though the laws are very different for her as opposed to everybody else in the world. I'm not certain how to handle this going forward. You have submitted your documentation and she wants to argue stuff that's not law, regardless of my rulings. So therefore, I'm not sure what to do with respect to your case.
I would ask for a directed verdict. She hasn't said anything that is a defense to my action. And I submitted a proposed judgment this morning. There's rent owing in the amount of $3,432.42, court costs of $177 for a total of $3609.42. We would ask for a judgment for possession with a writ after 10 days, and she can avail herself of whatever procedures she can in another court.
So you're saying that none of my objections is valid towards your claim. So having a valid contract is not an objection. Oh, because you're saying that because a notice was given and unrebutted, it's not of law. That's what you're saying, right?
Yes, that's not the law.
It is. It's the law. It's Wells versus Zendaya of Michigan. It is. It's
All right.
backed in case law. And y'all keep
Ma'am,
it's okay. Because he can talk, but I can't talk.
ma'am, you've argued that over and over, and I've ruled that it's not. You can file your appeals, file all the things you're filing, but when you file false liens against people, that is a crime.
It's not a false lien. You got defaulted on a private side, and you know that.
Okay, whatever. All right,
Yeah,
so
well,
what
okay.
I'm going to do is grant your judgment in this particular case because I've given her an opportunity to present defenses that are real, and she has refused to do that.
I didn't refuse to repent defenses. You didn't ask me about my piece of the case. I only got to cross-examine. You didn't ask me about my defenses.
What are your defenses, ma'am? And rescission is not one. I've ruled that it's not.
I'm sorry.
I know you heard me.
No, I didn't. You said, what are your defenses? And I
I
didn't hear the
know
last
that
piece.
your rescission is not a defense.
Okay, that's fine.
That is your defense.
Right, because, threshold matters are not an issue. But again, like I said, the fundamental objections and a counterclaim, object to the subject matter jurisdiction. You all accept and receive housing funds, making the
Your Honor,
subject
we're going
matter.
down the same road.
Okay, listen,
Not
stop,
yourself.
stop. I
No,
didn't cut
you
you off.
stop.
I didn't
I
cut y'all off.
said
You
it's
just asked
not.
me what my defense was. And
All right, I'm done.
wow. You're
Let
asking me what my
the
defense is. I
defendant,
can't.
take her out. I've asked her 3 times to stop this. All right, I'm gonna grant your judgment in this particular case.
Your Honor, are you going to check the box after hearing?
Yes,
Thank you.
thank you.
I'm sorry
Thank
you
you,
had to
Judge
go.
Washington.
I'm
Thank
sorry
you.
you had to go through that.
All right, thank you.
Thanks.
And
I'm
Thank
sorry
you.
you had to go through that.
All right, thank you.
Thanks.
appreciate it. Bye.
This case did not turn on complicated law, turned on focus. From the outset, the court was clear. This was a non-payment of rent case. That limited the issues to a few straightforward questions. Was there a lease? Was rent unpaid? And was proper statutory notice given? Instead of addressing those questions, the defense relied on sovereign citizen concepts. Unilateral rescission, claims of being not a legal person, silence as law, standing as law, and federal overrides through HUD procedures. These arguments can feel empowering because they challenge authority itself. But landlord-tenant court is statutory. It operates on written rules, not philosophical objections. This is where the consequences began to compound. Each time the judge ruled on jurisdiction and moved forward, it was a clear signal. The framework of the case had already been decided. Continuing to attack jurisdiction did not pause the proceedings. It narrowed the judge's patience. When objections do not align with the governing statute, they stop functioning as defenses and begin to look like a refusal to engage. The most costly moment comes when the judge asks for actual, legally recognized defenses and the response loops back to the same rejected theory. At that point, the outcome is no longer emotional. It is procedural. If no valid defense is presented, judgment follows. This pattern appears repeatedly in sovereign citizen cases. The belief is that exposing a lack of jurisdiction will collapse the case. The reality is the opposite. Courts presume jurisdiction unless it is overturned through proper appeal, not repetition. Strategic choices about what to argue, what to abandon, and where to focus determine the outcome long before the final ruling. And once credibility is lost, the court proceeds without hesitation.